Hello, everyone. This lecture is about advertisement, which is a legal and ethical issue. So what is an advertisement? It's helpful to begin by clarifying what counts as an advertisement. So for MFTs, advertisements are any form of public communication about your services, your mental health services that you provide. So this includes communications that are in speech, so talking, print, like a magazine ad or a billboard, or any media, so a radio announcement, a podcast, a website, etc. Other common examples include business cards, flyers, brochures, and so on. It's helpful to remember that while advertisements serve to bring you business, the board sees the purpose of advertisements as making sure that the public is well informed and not misled about the services that you provide. So there's kind of two different things going on here. Some legal issues, legal considerations. First off, you must always include your license number or registrant number, if you're an associate, on any kind of advertisement. Okay, so the actual number. You must also include your license designation. So whether you are an MFT trainee, a marriage and family therapy associate, or an LMFT, that needs to be on there. It is also illegal to mislead people by suggesting that you have a higher level of skill or expertise in your advertisement when in fact you do not. So for example, taking one class or workshop in EFT doesn't give you expertise in that. So you shouldn't write expert in EFT or specializes in EFT on your business card. Okay. Another issue is, let's say, for example, you go and pursue a doctorate, a PhD, but in a different field like history. You would need to make sure that in your advertisement, you're very clear that your PhD is not in clinical psychology, right? If you write Mary Sue, comma, LMFT, comma, PhD, everyone is going to assume that your PhD is in clinical psychology. And if it's not, that could be misleading. So you would need to indicate PhD in history or whatever. You also cannot make any guarantees in your advertisement that you can guarantee expectations. Okay, this isn't buying a mattress where you can guarantee it's going to be soft. You can't guarantee that your MFT work, your mental health services, are going to absolutely result in an improvement in symptoms within 6 months. You can't say that. So none of that legally. Okay. Ethically, it's considered unethical to ask clients to provide testimonials for your advertisements. So like if you were wanting to put a testimonial on your website, for example, that would be considered unethical. And the reason is that it may be taking advantage of the power differential between you and your client that existed in that relationship, meaning that the client may feel obligated to do it, to provide you a testimonial, even if they don't want to, because they have this relationship with you. There's potentially confidentiality issues, even if you change names, and these testimonials may mislead potential clients, acting as a form of guarantee. Oh, well, because it worked for these clients, it's gotta work for me, which may set up unrealistic expectations. I mean, we can see this if we look at comments or comment advertisements, I suppose, on like Yelp. Like when you read those, you think, oh, this place is going to be great if everybody else says it's great, right? And then sometimes you're disappointed. So the same applies here, but to a larger scale. And then any legal factors, so the ones we covered on the last slide, are also covered by the ethical code, so they count as both. Okay, next, related business ethics issue is fees and payments. Fees and payment are also a legal and ethical issues. So first, here are the basics. Legally, therapists must disclose their fees prior to the commencement of therapy. This includes how much the fee is, when the fee is due, how the fee can be paid, and what happens if the fee can't be paid or isn't paid. And we'll get to more of that later. So this means that one of the first things you should be going over, ideally within your informed consent in that first session, is fees and payment. Okay, so how much the fee is, that's obvious. When is it due? Are you collecting your fee at the beginning of the session, at the end of the session, at the end of the month, at the beginning of the month? What is that arrangement? How can it be paid? Are you billing insurance? If so, are they responsible for a copay? Are you cash only? Do you take checks? Do you take credit card? Are you pro bono? All of that needs to get covered. And then, as I mentioned, we'll talk about what happens if the fee's not paid a little later. And so all of this needs to be done at the beginning. Okay. If you plan to increase your fee after you've been working with a client, which you're fully entitled to do, you need to give the client a minimum 3 months advance written notice that you're going to increase your rate to give them enough time to potentially find someone else if they cannot pay this fee. Ethically, you are permitted to set your fee at whichever amount you would like, so long as it's not exploitative. So if you want to charge $150 a session, go for it. It is also not unethical or illegal to charge different clients different fees. Okay, here again, it's not unethical, it's not illegal to charge different clients different fees. This is essentially what a sliding scale is, right? So if you're taking their financial situation into account to set your fees, this is totally fine and is ethical, okay? So that's why that would be appropriate. You do want to make sure, however, if you're charging different fees, that it's not a discriminatory thing, that you're not just saying, oh, well, I don't like working with men, so I always charge them more. That would be discrimination. That is not okay. That is unethical, not good. So there has to be some basis for why you're charging different fees. Okay, next. Payment for non-clinical services. So non-clinical services are things like case consultation, case management, testifying in court, things like that, okay? And you are permitted to charge for these services so long as you have informed the client in advance, meaning at the onset of treatment. So if you have in your informed consent, for example, that you charge $50 every half hour of case consultation, and they sign it and they agree, then you can go ahead and do that. You can't just do the case consultation and then afterward, when you're collecting your fee, be like, oh, by the way, I spoke to your kid's teacher for consultation for an hour, so that's going to be $100 extra. No, not only is that unethical, they're not obligated to pay you. Okay, don't do that. Okay, this reminds me, if for some reason you don't go over fees at the beginning of the session, and then at the end of the session, you say to the client, okay, you know, so my fee is going to be $100, so you need to pay me for that hour of therapy. Because you didn't disclose it at the onset of therapy, they aren't technically obligated to pay you that $100. So that's just another reason why you want to go over fees at the onset of therapy and collect your fees at the onset of therapy too. Okay. Bartering. So this is just a quick reminder about bartering. We've gone over it before. Remember that bartering is only acceptable if it's a practice that's accepted among the professionals in that community. So like in a reservation or an extremely rural area. It must be initiated by the client themselves. And you want to avoid bartering with services. So service for service. You would instead want to do goods for services. Just a reminder. Okay. As promised, what happens when clients can't pay? So during your practice, you'll likely find yourself in a situation where a client or potential client can't afford your fee. What you do in this case depends on the status of that particular client. If this is a potential client, meaning they've come in for their first session and you've informed them of your fee at the onset of therapy like you're supposed to, and they tell you, ooh, that's a little steep, I can't afford to pay it. What do you do? Ethically, you should help them find a therapist or an agency who offers a lower fee, meaning you give them some referrals, 3 at least, for low cost or no cost therapy. That's more in their price range, okay? You're not obligated to lower your fee in this case because this is a new client and you don't have an established relationship. Now, if you already offer a sliding scale or you have a certain number of slots for pro bono services, then it would be appropriate to offer this client one of those spots or to discuss your sliding scale, but you technically are not obligated to do so, okay? You would not, however, start seeing the client knowing they can't afford your fee and then try to go to collections or something to get this fee that they said they can't afford, so don't do that. Okay. Now, alternatively, if this is a client you already have a therapeutic relationship with, you've been seeing them for a couple months perhaps, and they've been paying your fee, but for some reason they can no longer afford your fee. For example, they lose their job, right? In this case, ethically, you want to consider lowering your fee temporarily or even consider a pro bono arrangement or a payment plan of some sort, okay, in order to continue seeing this client and not abandon them, given that you already have an established relationship, okay? If you choose to do any of that, a lower fee, pro bono, payment plan, whatever, you need to be sure to establish boundaries around it. For example, how long are you going to allow the lowered fee or the no fee? When are you going to reassess? Okay. You're not obligated to do this, right? You can refer the client out, but you're strongly, strongly encouraged to try to make it work with this client, at least temporarily, because of the established relationship. Okay. Okay, so let's look at an example. A client who's been in treatment for 5 months for major depressive disorder, or major depression, excuse me, recently lost her job and tells her therapist that she can no longer afford her full copayment, but wants to continue therapy. The therapist should, A, refer her to get unemployment benefits, B, reduce her copayment, C, reduce her copayment temporarily, but inform the insurance if that is done, or D, refer her to a low-fee community mental health center. So take a moment and then we will discuss. Okay, so in reading this, a couple things that hopefully you pulled out. First, this client's been in therapy with you for a couple of months. Okay, so this isn't an initial appointment where you can just kind of refer them out. They have an established relationship with you. They have major depression, which does heighten risk a little bit when you consider like something like losing a job, which can be very stressful. And it's an issue with copayment, meaning that the client has insurance. So the insurance is likely covering the bulk of the session. Okay, so looking at our answers, A, refer her to get unemployment. This goes a bit outside of your scope as a therapist. This isn't a mental health services. You can provide her with resources, absolutely. But this isn't really what you would do, you know. And also, even if you are providing resources, which can be very helpful, this isn't, more importantly, this isn't addressing the problem at all. Like, okay, go find a job and then come see me. Not so much. B, reduce her copayment. That's potentially an option. Okay, let's look at C. Reduce her copayment temporarily, but inform the insurance if that is done. This is a strong answer and would knock out B for two reasons. One, it says temporarily, indicating that you're setting boundaries around this change to the payment. And second, informing the insurance. This is really important. If you're billing insurance, they must know if the client is not going to pay their copay. Okay, you can get yourself into some trouble and potentially get kicked off the insurance panel if you don't do this. So it's important to let the insurance company know if you're making this kind of arrangement with the client. Okay, so this is looking like a good answer. D, refer her to a low-fee community mental health center. This would be great if you didn't have an established relationship with the client. But in this case, the best answer, you're still going to get paid, C. Okay. All right. Insurance advocacy. If a client is paying for therapy through insurance, one thing we may encounter is the client running out of sessions. So there is usually a cap with insurance companies of the number of sessions the insurance will pay for. It's normally something around 12 to 18, okay? And in many cases, this is enough and you can stop seeing the client. Their issue has been decently resolved and it's okay. But in other cases, this just isn't enough. The client is perhaps in crisis or you're doing some trauma work, which is more extensive. So if this happens and you feel that the client needs additional sessions and the client obviously wants additional sessions, if they don't want them, then you close. But if you feel the client needs additional sessions and the client wants them, we are ethically encouraged to advocate for the client by contacting their insurance company and asking for an additional couple of sessions. So this would be insurance advocacy, okay? And because you're already billing insurance, you're allowed to do this in terms of confidentiality, so long as the client actually wants more sessions and you feel that they are clinically necessary. All right, next, debt and termination. It would be acceptable ethically to terminate a client if they have a running debt for therapy. So they haven't paid you for a while now. Perhaps they owe you a couple $100s or something like that. So that is okay, but there is a process for doing this, okay? First, you'd want to talk to the client about it and see if you can come up with a payment plan so they can repay the money that they owe, okay? If the client does not agree or they're not going to be able to make payments and they're not in crisis, you can terminate, okay? And that is ethical. If the client is in crisis, you don't want to leave them hanging. You'd want to resolve that crisis before you consider terminating. Now, assuming you've terminated, what do you do about getting the money that they owe you? This is where collections may come into play. So long as you've made them aware in an informed consent document that you use collections in the event of a running debt, you could go to collections to try to get that money back for yourself. This should be done in a last resort kind of thing though, okay? Now, if it's not in your informed consent that you will use collections to collect running debt, then you cannot do so. This would be a breach of confidentiality. So you're kind of forced to just send letters to the client or something of that sort to try to get your client to pay you, okay? Finally, please remember that you're not legally permitted to withhold a client's records solely because they haven't paid you for sessions. So if you did terminate the client and they're going to go see a different therapist, for example, you can't just refuse to share information with a therapist because the client owes you money as like a blackmail kind of thing. So don't do that. That is illegal. All right, the last topic here with business ethics is a professional will, which I had never heard of prior to studying for the law and ethics exam, so I'm going to teach you about it. So what is a professional will? Basically, it's a document that outlines steps that should be followed in the event that something happens to you, the therapist, that makes you incapable of practicing as a therapist, such as severe disability or death. This is designed to help keep your clients from being abandoned in the event of your death or incapacity. So let's say, for example, you are in a severe car accident and you go into a coma. If there isn't a professional will in place, what happens to all of your clients who were working with you, right? So that's what this helps with. The professional will should include the name and contact information for a designated therapist who would become the exeter of the will, meaning that they would oversee your records and referrals, okay? And we want a therapist, a licensed therapist, for ethical purposes. It should also include a designated bridge therapist who will handle transitions from you to the new therapist, again, to avoid abandonment. So this therapist is agreeing to kind of absorb all of your clients and help either terminate with them or, you know, resolve any crises or whatever, or provide them referrals so that they aren't abandoned. It should also include information about where the client's files, contact information, and billing information is located so that this bridge therapist can find them and be able to do what needs to be done with them. Okay, so professional will. Most important if you're in like private practice. For an agency, they would end up kind of taking over, but it's still good practice to have. Okie dokie, that's it for business ethics. Let me know if you got questions. Thanks, everybody.